F3315.
The Crown case against John Francis Flanagan arises from an incident occurring in the Flanagan home when it is alleged by the Crown the husband, John Flanagan, wounded his wife, causing grievous bodily harm. The scene opens during committal proceedings against Flanagan, taking place in the not unusual surroundings of a back room at a suburban magistrate's court. The stipendiary magistrate is hearing the evidence. To his left sits the clerk of courts.
I am an official police photographer attached to the Forensic Science Laboratory. At about 7:30 p.m. on the 14th day of August at the Royal Melbourne Hospital, I took some photographs of a Mrs. Rita Flanagan. I produce enlarged copies of these photographs. Photograph number 1 shows injuries to the left hand. Photograph number 2 shows a wound on the top of the head.
I am a legally qualified medical practitioner at the Royal Melbourne Hospital. On the 14th day of August, in the casualty ward of that hospital, I saw a woman who I was told was Mrs. Flanagan.
Doctor, don't worry about the clerk. This one has a machine.
No. She had numerous lesions, 2 on the back of her right hand and 3 on the inside of her left hand. She also had several large wounds on the top of her scalp. These wounds were sutured. She was given penicillin, anti-tetanus serum, and anti-gangrene serum. The wounds on the top of her head were caused by a sharp instrument the broken jar produced.
My name is Myrtle Brown, and I live at 12 Rugby Street, Collingwood. On the 14th day of August, I was just coming home when I heard someone scream.
What did you do?
Well, I thought it must...
Don't tell us what you thought, Mrs. Brown. What did you do?
Well, I stopped, and I saw this lady come out and sit on the steps.
Did you have a conversation with her?
Yes.
What did she say?
Well, she said
Was
it's
our
all
client present when this
Flanagan's fault.
conversation took place?
She meant that her husband had bashed her
Look,
up.
why
I could
are
see
a
that she
dog
was
and do
very
your own
badly
barking?
hurt.
You're objecting, Mr. Bilson.
No, Your Worship, I was not objecting. I was merely conferring with my instructing solicitor.
Well, don't interrupt.
No, Your Worship.
Go on, Mrs. Brown. What was said?
Well, I said, what's the matter? What's wrong? And she said it's all Flanagan's fault. My husband. She meant that her husband had bashed her up. I could see that she was very badly hurt. You know, blood and all that. So I rushed away to get the police. That's all I saw.
When I was passing the house, I saw her fighting and struggling in the corridor with him. There was blood all over the place. He was hitting her. Well, anyway, trying to hit her. He had this broken jar. Then the police came.
My name is James Jackson, and I'm a constable stationed at Collingwood. On the 14th day of August at 308 Gore Street, Fitzroy, I saw a woman who I know to be Mrs. Flanagan in premises at that address. She had blood on her face, head, hands, and clothing. Later that day, I again saw her at the casualty ward at the Royal Melbourne Hospital. At the premises at Gore Street, Fitzroy, I saw the broken jar produced on the floor. It was covered with blood. I also saw the defendant there. I indicated to him that I wished him to leave the premises and wait for me in the police car outside.
And he said I couldn't have the money. And when I tried to get the jar it was in, he tried to grab it from me and hit me. Well, when he did grab the jar from me, I grabbed it back from him and he grabbed me around the waist and threw me against the wall. That's when I screamed out. Then I went outside to get away from him. When I came inside again, he had the jar. And when I tried to get it from him, he started punching me and hitting me.
I said to the defendant, what way is this to treat your wife? And he said, and I won't forget this to my dying day, he said, one of these days I'll shoot her. A man is better off dead than putting up with this.
Do you acknowledge yourself bound in the sum of $400 to appear at the Supreme Court at Melbourne on the 1st day of October and there give evidence on the trial of the accused?
Yes. Oh, very well.
Oh, certainly.
Members of the jury, the prisoner, John Francis Flanagan, is charged with wounding with intent to cause grievous bodily harm. To that charge he had pleaded not guilty, and for his trial has placed himself on God and his country, which country you are. Your duty, therefore, is to say whether he is guilty or not guilty. Hearken to the evidence. You choose your foreman.
A jury tends to choose as its foreman a person who has previously appeared on a jury. When the jury arrives at a decision, the associate takes down the name of the foreman.
Prosecutor, the prisoner is now in charge.
Please, Your Honor, I appear for the accused.
Members of the jury, in this case, the Crown alleges that the accused, John Francis Flanagan, did on the 14th day of August wound his wife with intent to cause her grievous bodily harm. It is my function, appearing for the Crown, to explain to you briefly at this stage what this case is all about. Now, witnesses will describe that on the 14th day of August...
The first witness for the Crown is Mrs. Flanagan, wife of the accused. She has been called after the judge has ruled, in the absence of the jury, that she is a competent and compellable witness against her husband.
Now, Mrs. Flanagan, I want you to take your mind back to Friday, the 14th of August of this year. At about 5:30 on that day, were you at home?
Yes,
And was your husband also at home at that time?
of course.
You'll tell His Honour and members of the jury what happened between you and your husband on that day?
Well, it was a long time ago.
What? 10 weeks, a long time ago?
I object, Your Honor. Learned prosecutor can't cross-examine his own witness.
Yes, I think that's right.
Mrs. Flanagan, what happened between you and your husband on that day?
You must answer the question.
I really don't remember.
Would you have a look at what's being shown to you, Mrs. Flanagan?
Your Honor, this amounts to cross-examination, too.
Yes, how do you put this, Mr. Prosecutor? Under Section 34 of the Evidence Act, you need the leave of the court, do you not?
What I'm seeking to do, Your Honour, is follow the procedure adopted by the Chief Justice of the High Court and the King and Kneel.
Yes, I remember. Well, I think we'd better examine this in the absence of the jury. Members of the jury, it seems there's something else I must decide here. Perhaps you'd like to return to your jury room and have a smoke? Mr. Prosecutor, I take it you have some statement of this witness, do you?
Yes, Your Honour. I want to put it to the witness or put some passages from it to the witness.
But that's precisely what the learned Chief Justice did not allow counsel for the Crown to do in Neil's case. He allowed counsel to show the witness a statement and to ask leading questions on it. But he did not allow him to read any passages to the witness or allow the witness to read out any passage.
Well, in that event, Your Honour, my application would be that Your Honour declare the witness hostile and allow me to cross-examine her on all matters relevant to the issue.
Well, that's your application. You better proceed with it now in the absence of the jury.
That is my application. I wish to prove the witness has made a statement inconsistent with her present testimony.
Your Honor, in my submission, there is no evidence on which Your Honor could find that this witness is adverse or hostile. The fact that she has not given favorable evidence does not show hostility. What has to be shown is that she's being deliberately untruthful or obstructive.
Well, Your Honor, I want to avoid this. In my submission, this is quite absurd. I cannot establish that he is adverse unless I can cross-examine her, and I cannot cross-examine her until she's ruled to be adverse.
Yes, I'm familiar with the problem. Do you want to prove the making of this statement aliundi?
Yes, Your Honor. I will now call the police witness.
Well, you may stand down, Mrs. Flanagan.
Can I go home now?
No. If you just take a seat and wait in the court.
Constable Jackson, did you interview the previous witness, Mrs. Flanagan?
Yes. On the 14th day of August, I interviewed the previous witness. She thereupon made a statement which I reduced to writing and read over to her. She signed it in my presence. I produced that statement.
Read it, will you?
Yes, Your Honor. I, Rita Mary Flanagan of 308 Gore Street, Fitzroy, state as follows. My husband belted me up because I wanted to get some money from a jar that we keep in the kitchen to buy my brother a present. I did not give him any reason other than this for assaulting me. As a result of these assaults, I received wounds to my head, arms, and hands. It was signed by a witness in my presence.
Well, yes, Mr. Prosecutor, you may proceed under Section 34 of the Evidence Act. I think this matter is governed by the Queen and Hunter, isn't it?
Yes, Your Honour. 1956 Victorian Law Reports, page 31. It overruled an earlier decision in Bassett and Ferguson in 1952.
Yes. Bring in the jury.
Your Honour, please.
Mrs. Flanagan, on the night of the 14th of August, you made a statement to the police, did you not?
I didn't send for the police.
Did you make a statement to the police?
Wish they hadn't got mixed up in it.
Mrs. Flanagan, the question is, did you make a statement to the police?
Yes.
That is the statement, is it not?
Yes.
I tender the statement, Your Honour. May I read the statement, Your Honour?
Yes, you may.
As a result of these assaults, I received wounds to my head, arms, and hands.
I would ask, Your Honour, at this stage to direct the jury that there is no evidence that the statement is true, only that the witness made that statement. This appears, Your Honour, from the judgment of the full court in Hunter's case.
Yes, I think I shall so direct them. Hand me the report of Hunter's case, will you? Members of the jury, this evidence does not establish that the statement is true. It merely establishes that at some stage this witness made this statement. Do you follow me? There is no evidence that it is a true statement.
Mrs. Flanagan, you've told His Honour and members of the jury that you made this statement.
Yes.
The statement is true, isn't it?
No.
No.
No, it isn't true.
Is none of it true?
No.
Look, is it true that your name is Rita Mary Flanagan?
Yes.
Is it true that you live at 308 Gore Street?
Yes.
Is it true that your profession is a housewife?
Yes.
Is it true that on the night of the 14th of August you received wounds to your head?
Yes.
And it's true that your husband, the accused, caused them by striking you with a glass jar?
No, it isn't.
Well, Mrs. Flanagan, would you tell the jury how you received these wounds?
The statue fell off the mantelpiece and hit me on the head.
A statue fell off the mantelpiece and hit you on the head? Are you serious, Mrs. Flanagan?
Yes, I am serious. That's how I got hit on the head.
Did you tell the police that?
Oh, I don't know what I told them. I was upset.
Your husband's been on bail up to now, hasn't he?
Your Honour, there is a matter of law that I desire to mention in the absence of the jury.
Very well. Would you mind? What is the matter of law?
I apprehend that the prosecutor is going to suggest to this witness that the accused has approached her to alter her evidence.
And why do you apprehend that?
It's my nasty, suspicious nature, Your Honour.
Well, what if he does? Hunter's case suggests that the right to cross-examine in these circumstances is much wider than was earlier thought. Certainly sufficiently wide to permit cross-examination as to matter relevant to the issues before the court. Now, may not the prosecutor put this as an admission by the accused that he's guilty of the offense of which he's charged, namely that he sought to make his wife change her evidence? I take it that's what you propose to do, Mr. Prosecutor?
Certainly, Your Honour.
Well, that would be quite contrary to the spirit of the law in my submission, Your Honour. The accused has not put his character in issue or attacked the character of any Crown witness. And it'd be quite wrong for the prosecutor to introduce by the back door in this way material which would be so prejudicial. It's really eliciting evidence that he's guilty of a completely fresh crime, suborning a witness.
In my submission, Your Honour, if this is relevant as going to an issue, the fact that it is incidentally revealing something discreditable about the accused, or that he is of bad character, will not prevent the material being admitted. Your Honour is familiar with the decision in Atwood's case, the High Court case?
Yes, I am.
Your Honour, it is submitted that whether or not this evidence is technically admissible, Your Honour has a discretion to exclude it. I refer, of course, to the principles laid down in Noor Muhammad and the Queen. That's reported, Your Honour, in 1949 Appeal Cases 182, and I think a most convenient reference is to the speech of Lord du Parc on page 192. In all such cases, the judge ought to consider whether the evidence which it is proposed to adduce is sufficiently substantial, having regard to the purpose to which it is professedly directed, to make it desirable in the interest of justice that it should be admitted. If, so far as that purpose is concerned, it can, in the circumstances of the case, have only trifling weight, the judge will be right to exclude it.
Well, Mr. Prosecutor, what's the situation? Are you really pressing this evidence?
I am, Your Honor. I am pressing for it because I have very good reason for it.
Well, if you assure me that you have good reason for it, of course I accept your statement without question. But I wonder if you could help me in this matter. I'm looking at Section 400 of the Crimes Act, and I direct your attention to subsection 4. It reads, "Nothing in this section shall in any way affect the operation of Section 27 of the Evidence Act, 1958. I take it you're familiar with Section 27.
Not intimately, Your Honor.
Oh, well, then I shall read it to you. No husband shall be compellable to disclose any communication made to him by his wife during the marriage.
I'm not seeking to do that, Your Honor.
And no wife shall be compellable to disclose any communication made to her by her husband during the marriage. Now, surely that determines this matter quite apart from questions of discretion.
Yeah, well, I haven't had an opportunity to consider this section, Your Honor.
Well, then consider it. Because it seems to me that unless you can persuade me to the contrary, that section prohibits the course of action you propose. And I don't imagine that Mr. Bilson will be wanting to persuade me to a contrary view.
No, Your Honor.
Had you thought of that section?
Never heard of the section.
No, Mr. Prosecutor, I don't think you should continue with this line of cross-examination.
Your Honor, please.
Bring in the jury. Yes, Mr. Prosecutor.
Your Honor, I have no further questions of this witness.
Well, do you wish to cross-examine this witness, Mr. Bilson?
Look, Mrs. Flanagan, these wounds on your head, they happened when a statue fell on you, didn't they?
Oh, Mr. Bilson, she's already sworn that. Do you think you can take it any further?
Well, Your Honor, I have to conduct my case as I think best.
Well, of course you do, and you've been a great assistance to me and to the jury. But do you really want to ask this question?
Yes, Your Honor, unless Your Honor directs me not to.
I can't direct you not to ask it.
Very well, Your Honor, I propose to ask it.
Very well.
Witness, these wounds on your head, they happened when a statue fell on you, didn't they?
I think so.
And that happened when you and your husband were quarreling about housekeeping money, didn't it?
Yes.
Then you tried to get the jar down from the shelf, and he tried to get it from you, and in the struggle, you fell against the wall, or he fell against the wall, and you both went on struggling, and then the statue fell.
Well, Your Honor, that's at least 6 questions, not 1.
So I don't know about the arithmetic, but that's certainly more than one question, isn't it, Mr. Bilson?
Witness.
Look, it was an accident.
Do you wish to re-examine, Mr. Prosecutor?
Yes, Your Honor. What was an accident?
The whole thing.
Mr. Prosecutor, I think this might be a convenient moment to adjourn.
Your Honor, there are some matters of law that need to be discussed in the absence of the jury after the luncheon adjournment.
Well, thank you, Mr. Prosecutor. In that case, I shall ask the jury not to come back into court until these matters are disposed of.
Your Honor, please.
Yes, Mr. Prosecutor.
In the first place, Your Honor, it is desired to tender evidence to the effect that on 2 earlier occasions, the accused assaulted his wife in circumstances similar to the present circumstances.
But this evidence is not in the depositions, is it?
No, it wasn't led at the committal hearings, because I imagine the view was taken it was inadmissible. But now that it appears that the defense in this case is one of accident, I would like to lead you to rebut that defense.
But how am I to know that the defense here is one of accident?
Well, by the evidence given by my learned friend's client.
Oh, you mean Mrs. Flanagan?
Yes, Your Honor.
That's not your learned friend's client. That's your learned friend's client's wife.
I beg Your Honor's pardon.
Well, what's the start point for this matter? Making in the Attorney General, isn't it?
Yes, Your Honor. In the speech by Lord Chancellor Herschel. It is undoubtedly not competent for the prosecution to adduce evidence tending to show that the accused has been guilty of criminal acts other than those covered by the indictment, for the purpose of leading to the conclusion that the accused is a person likely, from his criminal conduct or character, to have committed the offence for which he is being tried. On the other hand, the mere fact that the evidence adduced tends to show the commission of other crimes does not render it inadmissible if it be relevant to an issue before the jury. And it may be so relevant if it bears upon the question whether the acts alleged to constitute the crime charged in the indictment were designed or accidental, or to rebut a defence which would otherwise be open to the accused.
Thank you, Mr. Bilson. Well, Mr. Prosecutor, that's still the law, is it not? How do you say that the evidence of these earlier assaults is admissible? Your difficulty is referred to in Thompson and the Director of Public Prosecutions, is it not? Where Lord Sumner says that before an issue can be said to be raised, it must be raised in substance, if not in so many words. What does his lordship say? You cannot credit the accused with fanciful defences in order to rebut them at the outset with some damning piece of prejudice.
I agree with respect, Your Honor, but here the matter has been raised, not merely in substance, but in words, when Mrs. Flanagan says it was all an accident. The statue fell on my head. Well, there's a fancy defence if ever there was one.
But how am I to know that's the defence?
I inform Your Honor, if it is of assistance, that I will not be contending here that this wounding took place as the result of an act of the accused that was an accident. Our position will be that these wounds were not caused in the strict sense by any act of the accused at all, but by the statue falling off the mantelpiece.
Yes, well, I can't ask you what your contention will be. Is it proper for you to inform me?
I believe so, Your Honor. That was the course followed in a New Zealand case, the King and Horry. It's reported in 1949 New Zealand Law Reports, page 791.
Yes, I think you're right. But tell me, if you may, what do you say as to the events described in the depositions by the witness Smith, the events which took place in the corridor?
I will be contending that there is no evidence that any wounding took place on that occasion, and further, that there is no evidence of any intentional act which resulted in any damage, wound or not.
But what about the question of assault? Isn't a verdict in relation to that offence open on this presentment?
No, Your Honor. The matter is governed by Section 423 of the Crimes Act, and the only statutory alternative verdict is one of unlawful wounding, a misdemeanor under Section 19 of the Act. And the fact that a verdict of common assault will not be allowed to stand was decided in Victoria as early as 1869.
Yes, well, I don't think I would have exercised my discretion in favor of the Crown. But Mr. Bilson having made the indication that he has, do you want to press this matter?
No, Your Honor.
Very well. Now, while the jury is still out, what about the evidence in the depositions of Mrs. Glupta? It appears on page 5 of the depositions. She's apparently a neighbor, and she says that she heard the accused say about his wife, "One of these days I'll shoot her," and so on. I take it that you wouldn't want to lead that evidence, would you, Mr. Prosecutor?
Yes, Your Honor.
You would?
Yeah.
But it's pretty thin, isn't it? It appears that those remarks of the accused were made some 2 years before. And there's evidence that during those 2 years, the accused and his wife lived together amicably.
Well, my submission is that's merely a question of weight, Your Honor, not admissibility. The jury might think that after 2 years the remark had no significance. Well, they might think it was significant. I think the matter is entirely up to them.
I don't think it's as simple as that. There comes a point when evidence becomes so weak as to be not worth noticing. And I don't think it's solely for the jury to say that.
Well, Your Honor can no doubt caution the jury about this evidence by pointing out that there may be many people in the community who, many years ago, did not see eye to eye with each other, but they've settled the differences and now have lived happily ever afterwards.
Where are you quoting that from?
I wasn't aware I was quoting it from anything, Your Honor.
Well, it must be a case of extrasensory perception. That's very much what the trial judge said in The Queen and Singopoulos. And the full court was of the opinion that he should have excluded evidence of just that sort. And the court approved the language of a Canadian case in which it was said that It was important that courts should not slip into the habit of admitting evidence which, reasonably viewed, cannot tend to prove motive or to explain the acts charged, merely because it discloses some incident in the history of the relations of the parties. You better take a look at Singopoulos' case. It's in 1964 Victorian reports. And you might also look at the Canadian cases, and then decide what you think should be the position of counsel for the Queen.
I will, Your Honor.
There is one more thing, Your Honor.
Yes?
It arises from the evidence of Myrtle Brown, Your Honor, who appears on page 2 of the depositions as saying to Mrs. Flanagan, "What's the matter? What's wrong?" And Mrs. Flanagan replies, "It's all Flanagan's fault." Now, in my submission, Your Honor, that is plainly hearsay and not admissible. Might I address Your Honor on the hearsay rule?
No, I hope that won't be necessary, Mr. Wilson, although I'm sure it will be very instructive. Mr. Prosecutor, how do you put this?
As a recent complaint, Your Honor, she's saying that her husband did it.
Well, what if she was? And it's not clear to me what she was saying was her husband's fault. How is it admissible? Admissible recent complaints are confined to sexual charges, are they not?
Well, in Wink's case...
Yeah, I know there are old suggestions to the contrary. But the modern view is that this is a survival of the hue and cry, is it not? Our ancestors in the Middle Ages regarded it as an essential part of the Crown case. If the prosecutrix in a rape trial did not raise the hue and cry, she was presumed to have consented.
But this evidence supports her statement to the police.
Well, that's not the point. Statement to the police is not evidence.
Why has it got an exhibit number on it?
What?
The exhibit number. That, of course, is the fact. But I do not urge Your Honor to draw the same conclusions he does from that fact.
And you'll have to instruct him, Mr. Prosecutor, in the distinction which has to be drawn between documents being evidence of the facts contained in them and documents being evidence of the fact that they were made.
Yes, Your Honor. Now, I submit it's all Flanagan's fault, related to part of the raised jester, and his inference may fairly be drawn from it, therefore it is admissible. Now, as early as the 17th century in Thompson and Trevanion, Lord Chief Justice Holt, in a civil action for assault, allowed what the wife said immediately she'd been hurt, and as his lordship said, before she had time to devise or contrive anything for her own advantage, to be given in evidence.
Well, I doubt that that's this case. Mrs. Flanagan didn't say when the hurt was received. I reject that evidence, Mr. Prosecutor.
Your Honor, please.
Well, does that conclude the matters that have to be examined in the absence of the jury?
All except one, Your Honor. Your Honor will notice from the depositions that a witness, Jones, a medical practitioner, says, amongst other things, that in his opinion, the wounds on her head were caused by a sharp instrument, the broken jar produced. Now, Your Honor, in my submission, that evidence is not admissible. It's quite clear from Mrs. Brown's evidence that Mrs. Flanagan had some wounds on her head before any witness swears to having seen the jar in the accused's hands. It is therefore most unlikely that the wounds were caused by that jar.
But that is not an argument affecting admissibility. The fact that there may be other evidence indicating that the wounds were not caused by the glass jar does not mean that evidence that they were caused by the jar is inadmissible. It only means, if anything, that the evidence about which you now complain is wrong. And whether it's right or wrong is a matter for the jury to decide, and not for me.
But, Your Honor, surely the only admissible evidence is evidence of facts, not of opinions.
But this man's in quite a different category. He's an expert, and he's entitled to give his opinion. You've no doubt read Mason's case. It was decided about 1912. In that case, the defense to a charge of murder was that the deceased had committed suicide. And a doctor who had heard the evidence was asked whether, in his opinion, the fatal wound was inflicted by someone other than the deceased. The Court of Criminal Appeal held that his answer was admissible as an opinion based on an assumed state of facts.
Yes, but, Your Honor, Dr. Jones here is not Sir Bernard Spilsbury. The mere fact that he's a medical practitioner does not prove that he's an expert in this field. For all that appears, he may have investigated one wound caused by a glass jar, or 2, or 20, or none. In my submission, he's not qualified to give this opinion evidence.
Well, unless the prosecutor can so qualify him by showing the extent of his experience in this field, I shall not allow him to give evidence that the wound was caused by the glass jar.
I'm obliged, Your Honor.
However, I shall allow him, on the basis of his medical experience, to give evidence that the wound is consistent with being caused by the glass jar. Does that satisfy you, Mr. Wilson?
The Lord gave, the Lord hath taken away.
You should complete the quotation, Mr. Wilson.
I beg Your Honor's pardon?
The quotation continues, "Blessed be the name of the Lord." You'll have the effect of that ruling explained to the doctor, will you, Mr. Prosecutor?
Yes, Your Honor. She had lacerations to the scalp.
Did the lacerations penetrate the inner and outer surface of the skin?
I object to that, Your Honor. That's a leading question.
No, it's not. It's directing the witness's attention to a specific subject matter.
As Your Honor pleases.
May I refer to my notes, Your Honor?
Were they written at the time?
Yes, Your Honor.
Very well.
Yes, they did.
It's quite clear that this witness is not referring to his own notes, but to hospital records. They would, in the ordinary course of events, have been made up by very many people. And in my submission, he can only look at his own notes.
Well, that's not so in my submission, Your Honor. The real point about material that can be examined to refresh a witness's memory is not that it is material brought into existence by the witness, but material which he saw when the facts were present to his mind and which then accorded with his own observation.
Yes, quite.
Now, Doctor, would you please tell the court what treatment was given?
She was given penicillin, anti-tetanus serum, and anti-gangrene serum. The wounds on her head were consistent with being caused by the broken jar produced.
And consistent with being caused in many other ways, Doctor?
Any sharp instrument?
Quite consistent, I suggest to you, with being caused by a statue falling and breaking on her head.
What sort of statue?
Any sort of statue.
It would need to be a pretty heavy statue and a pretty persistent one. It would need to fall several times to cause all of these wounds.
Did you find any fragments of glass in these wounds, Doctor?
No.
But you would expect to, would you not, if they were caused by the glass jar?
Not necessarily.
But probably.
Not necessarily.
Assume that Mrs. Flanagan had these wounds to her head before the jar was broken.
They could have been caused by the jar being broken on her head.
That's not quite the point. What I want you to assume is that these wounds were present on her head some 30 seconds before the jar was broken. Now, what do you say to that?
Well, if that were so, I say it unlikely that the jar caused these wounds. I think they were caused by a sharp instrument falling on her head.
Like a statue?
A sharp statue.